project frequently put people into various silos. There were the family law lawyers, there were the, every once in a while a consumer lawyer, but a lot of our offices didn't even have consumer lawyers just because they were so swamped with housing issues, so swamped with domestic violence issues and others that there just wasn't much in the way of other resources that could help. But what we found was that a lot of times survivors of domestic violence, while they were being relocated for their safety, they were also being sued by an ex-landlord saying you you left early from your premises, or they were being hassled, really abused by debt collectors that were trying to collect on their ex-spouse's Ford pickup. So we found that the silo approach to practice of law didn't work very well here, because consumer lawyers really needed to know about family law issues, and family law lawyers really needed to know about consumer law issues. And that's, I think Erica and her organization have recognized this, and as we have, and that was sort of the catalyst for getting this going. Now, one question for Erica or Sarah: can we go to the slides now? I still have the preliminary slide. Can we go to my PowerPoint now?
Sure thing. Are you seeing? Let me grab it for you.
Great. Now I see an arrow on the top. Can I push that? Will that take me to the next slide? I just tried it.
Are you seeing your slides now?
I'm seeing the cover slide. Okay, now I see the introductions. Okay.
Great.
So I pushed an arrow, and unless somebody else did it, I guess it worked. We've got this introduction, and Erica, I don't know whether you want to ask these questions, but is this our first our poll to see who we're dealing with in the audience?
Yep, I'll go ahead and open the poll right now and give it just a few seconds for people to give their answers. Once the poll closes, it'll take about 15 seconds to tabulate it and spit it back out. So if you'd like to move forward or just wait about 15 seconds.
Great. Well, I'll just tell people why we're asking this, is that it will focus a little bit if we're talking with consumer lawyers that want a little bit more information on how they can help their colleagues that are family law lawyers, or if we're dealing with family law lawyers, or if we're dealing with non-attorney advocates. It'll be useful in how we go with today's discussions. And then the second question is really, what kind of experience do you have? I'm expecting that many of you, the answer will be C. Okay, we're starting to see it here. 48% of the people are attorneys, 21% non-attorney advocates. We have others, which is always an interesting, and then a few that have no answer. The bulk of the group, 43%, are advocates have significant experience advocating for victims of domestic violence or survivors, and there's some with a mix. So that's sort of what we expected. Let's move on. I think I'm going to try clicking to the next slide. Let's see if my button does it. So I pushed something. I'm not sure. Okay, let me try this other one here. There we go. One of the materials, if you don't have this on your bookshelf, this is a really good volume, the Consumer Rights for Domestic Violence Survivors. A lot of what I have to say comes out of this book. You'll see that the book has 16 rules about how domestic violence survivors should prioritize their debts. I've gone through the book, and I have some tweaking of it. I think the book by itself is very useful, but it's a little bit like reading Shakespeare for the first time. Sometimes you need to put it in context. Maybe you need to know a little history or whatever. It's helpful, and also after this seminar, it would be useful for you to look at this book if you have a particular issue. one of the things I noticed in the book, and you can't really deal with it. There are unique issues for every state, dealing with exemptions, dealing with laws that may apply to collection agencies and the like. There is some federal law that applies to all states, but there are exceptions. But the book is good at helping you spot the issues and maybe think of questions, but it's not going to be a substitute for then going in and looking at your particular state statutes. Got a question here. We'll start with this. Thinking about this, if you're dealing with a survivor, there's probably lots of things that are coming. I mean, often people are in a situation where they had two incomes to support one household. Now they might have only one income or no income, but still have very similar hospital rent obligations and loan obligations. So if you don't have enough money, what do you pay first? You're going to pay that hospital bill, you're going to pay that payday loan, you're going to pay the rent. So we'll give a couple more seconds for the poll questions to come up.
Okay, I'm going to close up the poll right now.
I teach bankruptcy law at Seattle University, and a lot of times my students won't answer, and I say, look, you got to vote one way or the other. But let's see here. Well, let's hope we get some people voting. This is great. I mean, that is the right answer. I think in most circumstances, things change, but the rent is normally the piece that you've got to pay. I mean, the situation is that rent is paying for something that you're going to need in the future. The other obligations really may already have happened. But the general rule in the Domestic Violence Survivors book is pay your family necessities first. And rent, shelter and being sheltered from the elements is probably the most important thing that can happen. My caveat to the general rule is a lot of people will say, okay, well, medical bills, I've got to pay my doctor. But keep in mind that a lot of times the doctor bill is just a bill. If your loved one has already received the medical services and then you get a bill, in some senses it's no different than a credit card bill, and frankly, a lot of medical bills get charged on the credit card. So you may think the medical bill is critical, but if you've already gotten the services, rent could be much more important. Another caveat on this, though, a second caveat, and a couple of you, and maybe this is the kind of answer you give when you overthink the question, because it is possible that dealing with a payday loan may be the most important thing to deal with first. And the reason why I say that is that payday lenders frequently have direct access to a debtor's accounts. It's not uncommon for us to see someone that has Social Security or disability benefits being automatically deposited into their bank account. Now, Social Security is an asset that is not subject to garnishment, but payday lenders are not garnishing those funds. They know when the automatic deposit hits the bank account, and they go grab it because they've been given access to that bank account. It's voluntary. The access has been voluntarily granted, so it's not a garnishment. So if you have a client that has a payday loan outstanding and their revenues that they're going to live on are being automatically deposited in their bank account, you've got to be very careful because there may not be any money to pay the rent because the payday lender has snatched it up first. It's often good, you go to your bank and you eliminate the automatic deductions, but in our experience that doesn't always work, that somehow it comes through again, they try it in a different way, on a different teller or whatever, and the deductions happen. What we've had to do is often get our clients to go to another bank and open up a new bank account. A bank account where they don't have any past due obligations to that bank, a bank account that they have not given access to that account to any payday lender. The second rule in the consumer manual was pay housing-related bills next. Now, I'm going to shift to the caveat on this here soon too, is that sometimes you have to think about this a little bit. What is a housing-related expense? You know, mortgage payments and rent payments are really very different beasts. Now, the law in the various states is different, but I'm going to use Washington law as an example, and California law, other states, is not different in the major respects. But in a rental situation in Washington, the landlord can give a 3-day notice to pay or vacate. And if in 3 days the rent is not paid, an eviction action can be filed, and in a matter of a couple of weeks, a sheriff can be there forcing the people onto the street. It's a very quick process. On the other hand, mortgage foreclosure is a longer process. And frankly, a mortgage foreclosure is not always as bad on a person's credit history as an eviction. One of the things that we see, not just in Washington but in other states, is that landlords that actually go through with the eviction process, that gets reported on credit histories, and that's the biggest black eye that someone can have when they're going to get new housing. Landlords don't like to rent to people that other landlords have had to evict. They see if there was a foreclosure, well, maybe the rental business is going up because of the foreclosure business, and we haven't seen that landlords in the rental business really discriminate against people that have had a foreclosure on their record. But it really is a blemish on their credit record if they've been evicted. So the other piece is that the time frame for getting someone moved out of their house is much slower in a foreclosure process if someone had owned the home and is being foreclosed. In Washington, the quickest it can happen is about 120 days from the date of default. Washington, like California and many other states, is a non-judicial foreclosure state. Creditors will choose non-judicial foreclosure because it's quicker. In the states that have laws like that, it's very similar in what happens. First thing, there has to be a default. The default is followed by a notice. In Washington, there has to be a 30-day notice, meaning that you can cure the defaults in 30 days. If they are not cured in 30 days, then there's a 90-day notice of sale. And then after the sale, there's 20 more days that a person has to get out. So the time period is very long. And what's also very important to know that a lot of states don't, if the non-judicial foreclosure process is done, the states do not allow the creditor to come back after the homeowner for a deficiency claim. We have a real problem with a lot of landlords in Washington, and we've seen in other states, where after the eviction is done, then sometimes even years later, but sometimes quite quickly afterwards, they proceed to get a judgment for, the person is out, and once the person is forced out, then they go in and say, oh, the linoleum was damaged, the toilet was broken, the carpets are dirty, and by the way, they left before their lease was out, so we want $5,000. So they're looking for all sorts of deficiency type claims against the former tenant. In the foreclosure world, we don't see that. So you may have to make a big distinction between what kind of housing you have. There's an interesting law that came into effect a few years back. It's the Protecting Tenants at Foreclosure Act. It's at 12 U.S.C. section 5220 at CSAJ. And if you represent someone that is being evicted and they're being evicted, and they haven't been paying rent because the property was in foreclosure. Their landlord was in foreclosure. There are some 90-day notice provisions that are in there. So the short of this is a tenant in a rental situation, that rent versus a mortgage payment may have a much higher priority in the sense of protecting and keeping a family safe. Whereas the mortgage, if there's substantial equity in the house, you could lose financially as a result of the foreclosure, and that could be bad. But as a matter of emergent need, you have to really distinguish between making mortgage payments and making rent payments. The third rule in the manual was pay the minimum required to keep essential utility services. That makes sense. You got to have some oil in the tank to be able to keep heat on in the winter. One of the caveats that I have to add to this rule is that in Washington and in other states that I've looked at, utility charity is something that is frequently available. A lot of the utility programs, you've got public regulated utilities, and there are programs to deal with heat in the winter and lights in the winter and so forth. And there are a lot of charities. Catholic Charities here in Washington actually has some emergency help for people that need to keep their lights on or their heats going. So there are other resources out there for these. There's not as many resources to get someone to pay your mortgage payment, but there may be resources to get someone to pay the electric bill. Cars is a tough one because everybody, there's something about America, we really love our cars, and people don't want to lose their cars, but you really have to look at what the situation is. And sometimes cars are very essential for survivors because they're the best tool they have to be able to get away. But let me back up. I don't want to hit that one yet. But the thing with cars is you really have to think about whether it is necessary. One of the things to watch out for in cars, though, is that we see as consumer lawyers that cars sometimes are the biggest problem in debt collection areas. For one reason is a lot of our clients are unsophisticated and they get fleeced by the car dealers. Shortly after I came to Northwest Justice Project, I was going through a loan transaction, looking at the paperwork and seeing that our client had a 24% interest loan on a Toyota Scion that they bought that was 2 years old, and it was a terrible transaction. And I caught note of this because not only was the interest rate 24%, but the cost that person paid for that used car was higher than what I paid for a brand new car at the same time, the same model. So a lot of times our clients get pushed into these things with high interest rates and long loan provisions to get a payment down low. But those are really problems that are going to be surfacing later because cars don't last forever. Frequently they don't last for 5 or 6 years, but often the loan obligations are for 5 or 6 years. The payments don't go down over the 5 or 6 years, and if they miss some payments with the high interest rates, there's almost always a huge deficiency that the lender takes after the car is disposed of. And unlike the foreclosure of a house, which frequently eliminates any non-judicial liability, that is not the case with car loans. Let me shift now to the next polling question. What should a client do when repeatedly called by a nasty collection agent? Sometimes A is the obvious one, yell at the collection agent. Should they record the call? Should they send a letter? Or should they do both, B and C? Give a few minutes to deal with this.
Okay, I'm going to close up the poll.
Okay. And the winner is?
I'm going to hopefully spit out in about 5 seconds.
Okay. Good. I was trying to get one that where I was trying to give a tricky question, and I was hoping to get people to say both B and C. This is a tough one, is that in Washington, at least, B is not a good option. Several states have laws that make it illegal to record a telephone call without the other person's consent. So before somebody records the call, in Washington, what they would have to do is tell the people on the other side that the phone call is being recorded. In some states, that is not the law, but you need to be careful that you don't get your client in trouble to recording the call. But C, sending a letter, is almost always right. And we have I think it's going to show up in the materials, but if you don't get it on these materials, if you look at WashingtonLawHelp.org, which is our materials that we put out in Washington, but the letter that we have that's in the debt collection materials on WashingtonLawHelp.org is one that works under the Fair Debt Collection Practices laws. If you write to the collection agent and say, don't call me anymore, they can't call you anymore. And that's a great way of getting our clients protected. The limit on that is that in the industry, collection agencies often only hold the debt for maybe 3 or 4 months before they shift it over to somebody else. So a lot of times we give our clients this letter in a form where they can use it over and over again to keep from being hassled by the collection agencies. In a substitute for recording the call, it is a very good idea to tell your client to keep a log of what is said and how often they're called. We found that the courts are quite, find that very persuasive, that when the log is taken, that people have made contemporaneous recordings, written recordings of what happened. It is, they're usually believed by the court. And what we found is we get, and another thing you could do is you could have a witness there. If your client is really being hassled and their sister or brother are there at the time and can see how visibly upset they were, that is really important. Those type of things can make a big difference once the client gets situated, but they've been hassled by a debt collector that's been violating the law. Then with this record, you may have a good basis for a Fair Debt Collection Practices Act. Here is a situation where the family law lawyers at our office get their clients into safety, get them squared away, and then say, oh, by the way, here's the stuff that's been happening, and now they're being sued. What can we do with this? But if we have the log and we have the record of what has been done wrong, we can go from being a defensive posture into an aggressive posture and go out and sometimes even get injunctions against the practices. We've had the collection agencies do outrageous things which really upset the judges or any trier of fact. There was one collection agency in Washington. This guy thought he thought he was funny, but it was very nasty, and we know this was the case. We never caught this particular person, but he would call up. We often had young single women that were taking care of a few dependents. And when the collection agency would call and say, hey, pay, and the person would say, I'm sorry, there's no more blood in this turnip. You can't squeeze anything more out of me. And the flip response was, well, go strap a mattress to your back and go out and earn it. I mean, just really nasty things that violate any sense of justice or any conscience that anybody would have. This is back to the the slide before the last one. Is again, America's love with cars. Cars are really expensive, and you just can't figure out how much they cost until you have one. And changing the oil, paying the insurance, making the payments, buying new tires, and so forth. Sometimes it's not convenient to take the bus. Some places people don't have access to a bus. But we really had to help our clients in working out their budget. One of the few things that we could deal with in cutting their expenses has been a car, even though it hasn't always been the easiest thing to convince the client to do. The fifth rule in the manual was child support debts must be paid if the survivor owes them. Often child support is not just, sometimes the victim owes child support as well. And my caveat here is the same with all collection actions, is that there just may not be any blood in the stone. The sixth rule was that income tax debts have priority. There's a couple reasons for that. One, income tax debt normally is not discharged in bankruptcy, so that even if someone takes that relief at some point, they're going to be there. The debts are going to be there. A caveat, an important caveat in here is if you're going to deal with tax debt, that some people say, well, I can't pay the debt, so I'm not going to file a tax return. It's really important to file a tax return, because if you file the return, you show the IRS that you owe the money, but you don't have the money to go with it, there is a possibility that that tax debt can be discharged. The bankruptcy code allows for it to be discharged. 11 U.S.C. section 523A1, 523 of the bankruptcy code, provides that old taxes for which a return is filed are exception to the rule that taxes are normally not dischargeable. So filing tax returns is important. Another piece to look at is in the Internal Revenue Service Code. I don't expect everybody to remember this. And again, this is sort of like foreshadowing, that as I go through this, when you see the issues, you may not remember the answer that I give you or the code section, but it will jog your memory and it'll cause you to go back and look at it. But there is innocent spouse protections. Section 6015B of the Internal Revenue Service Code. I'm not a tax expert, okay? I don't assert that I am, but I do know that the innocent spouse rule can be very useful. In short, the taxpayer must establish that he or she had no knowledge or reason to know of the debt, and that under the circumstances it would be inequitable to hold the taxpayer liable. Basically, a situation, the innocent spouse rule is a very accurate title to it. If the innocent spouse rule did not know about the tax liability and the bad actor benefited from the lying to the IRS, and the innocent spouse got no benefit of it, and the innocent spouse is left with nothing, but the innocent spouse is the only one the IRS can find right now, well, it just wouldn't be fair under the circumstances, and there is some flexibility.
I just want to jump in. This is Erica. We have had some trainings in the past on tax advocacy for survivors, and if folks are interested in accessing those materials, they can easily do that on our website. We have a pretty extensive bunch of materials from our webinar on that. Also, if folks have individual questions about that, one of the consultants on this project is Susan Morgenstern, and we would be happy to provide folks with individual technical assistance where it's relevant.
That'd be very helpful. So, yeah, so people go to the sponsor's site to get that. I will say that looking at it, the IRS has some relatively helpful publications on it. you can get those publications by just Googling or Binging, innocent spouse rule, and put tax in the word. But make sure that you get to, you all know this, but you look at the first 4 things that pop up, and they're going to be paid sites where people are going to want fees to give you tax advice or something else. But if you find the IRS site, those publications are pretty useful. So at this point, I don't know, Erica, whether anybody has submitted questions to you, if they've any questions come in.
There are no questions that have come through, but if folks have them right now, if you want to send them to us through the chat, you're welcome to do that.
So we'll break again at some point, and if Erica sees some important questions popping up, she'll break in and alert me. But so go ahead and in the chat line, if you've got some questions, it can make, or even some great elaborations, it can make this much more interesting than me just droning on. The 7th rule was loans without collateral are of low priority. There's several caveats to this, like I've mentioned before. Whether a payday loan may not have priority because it's got collateral, but if they have access to the bank account, it's pretty important. And it may be that well, let's switch to the next slide. My caveat: there are no longer debtor prisons. And as I went through this, there is a couple typos in my my caveat here, but there are no longer debtor prisons, and there are exemptions, and there are limits on what debt collectors can do. Armed with those tools, we can protect our clients. And sometimes what I love is that I give the tools to some of my clients, and I can see them, they stop stooping. I have some clients that I can never let go of. They're just a little bit more fragile, or these things just, they can't deal with it. Other clients, when they learn that that the creditor can't do what they have said that they could do, my clients just feel empowered, stand about 1.5 inches taller, and are ready to go out there. I have a client that I just really adore, Mr. Frost. He was basically had 15 hours of income. He worked about 15 hours a week as a greeter in a large department store. And he had Social Security, and that's all he had. But he had several payday loans. He gotten onto that payday mill and was just, couldn't pay the interest, and they were automatically getting his payday, or getting his Social Security because they had access to his bank account. We switched his bank account so that the Social Security checks were deposited someplace else, and he could live on his Social Security, and the little bit of income that he had was above the exemption, the 30 times the federal minimum wage that was the law in Washington at the time, and is the law across the country, the federal law. So they couldn't get his wages, they couldn't get his Social Security, and he could basically give them the middle finger salute, that they couldn't come after him. And he was much stronger for it, and with my form letters. At first, the creditors would come back, the payday lenders would say that somehow Mr. Frost was trying to defraud them, that when he went in and got the payday loan, he knew that his only income was Social Security. Well, so did the payday lender. They took that risk, and they can't put him into jail. They can't flog him. They can't do anything. So the rights that creditors really need to know: you can't go to jail for debt in the U.S. Social Security is exempt. In most states, child support is also exempt. In Washington, it's RCW 6.15.010. But if those are your assets, creditors can't take them. And there's the Fair Debt Collection Practices Act. Also in Washington, in most states, there's usually a Collection Agency Act or something that's similar, that sort of supports the Fair Debt Collection Practices Act. But creditors, what they can do in trying to collect the debt is limited. Now, I want to give a caveat to my own caveat. There are 3 things to remember. One, I've been beating home this idea about direct access to accounts. Creditors need to be denied that direct access. That has to be taken away or they're going to get the money. Second point is voluntary assignments of wages is not usually a good idea, but creditors will keep saying, oh, give me a voluntary assignment and we won't have to garnish your wages. That's not a good idea because often our clients have more than one creditor coming after them. If it's a voluntary assignment, that's not subject to the limits on garnishment. Garnishments can only take at the most 25% of a person's disposable earnings. If you've taken 25% of the disposable earnings and taken the voluntary assignments, the clients could be left with virtually nothing. There are exceptions to that 25% rule for states going after child support and other things, but I'm talking here about the bank credit card debts, the medical debts, and so forth. Now, 2 more points on this, 2 more points on my caveat. There are exemptions. There's a game that collection agencies would play when they would call people into supplemental examinations, and they'll say, how much money do you have in your pockets? You know, and people would say, well, I've got 20 bucks, and they'd say, give it to me, or whatever. Well, there are exemptions. For example, in Washington State, $500 in a bank account is exempt. You just can't get that. So the client has to claim it. And also, cash in a mattress. It's not just $500 in a bank account, but it's up to $1,000 of cash, 500 of which can be in a bank account. So if a debtor goes into a supplemental examination and the creditor's asking, you know, where your money is, and if they've got a couple $100 bucks, they don't have to give it to them. They can claim it as exempt. Now, the last point I want to make on this caveat is the supplemental proceedings. Here is the only place where debtors are at risk of being incarcerated. Some of you may have heard it. There was an NPR piece on this, and I was one of the people that they called and interviewed. It was kind of fun being on, as opposed to listening to NPR, being you know, asked questions by the reporters. But supplemental proceedings are available in every state. Once someone gets a judgment, it's fair game to ask the judgment debtor what property they have to see if the judgment can be paid. And if these questions, in a lot of states, the way you do supplemental examinations, you get an order of the court requiring someone to appear and answer questions. If they don't appear, they can be put into jail for contempt for not appearing and not answering the court order. They're not being put into jail because they don't have money. They're being put into jail because they ignored a lawful order of the court. So you have to be careful about supplemental orders. If a client has a judgment, you know, when you go through and you tell them, hey, you don't have to pay that, you don't have any money, everything you have is exempt, that is fine, but they may have to tell that to the debtor or to the creditor as well and tell them at the supplemental proceedings. Sometimes, and in some states, that requires people to actually show up at court and make the answers. And that process can be somewhat intimidating. So, you know, I will accompany debtors in some of those situations. Frequently when I'm involved, though, what I can do is the client can provide written responses. And written responses will be in lieu of actually having to show up. But you really have to be careful about the supplemental proceeding, and because creditors will use it as a tool to get people to pay. They will threaten jail when it doesn't really exist.
Fred, would you like to take? We've got a couple of questions. Would now be a good time, or do you want to wait until?
Let's take it. Yeah. Okay.
Because people are being very good friends with one another and answering each other's questions too. So. One person asked, I'm sorry, the list moves as I try and read it. What solutions are there when the survivor has to turn the car back in and they are now being sued for the deficiency of the repossession sale?
Yeah.
Not sure if this is beyond the scope of what we can talk about.
No, that's a fair question.
Okay.
Frequently, the deficiency claims, I don't know how many out there have been debated in high school, but sometimes it's easier to be on the negative than it is to be on the affirmative, because you can just go through and look to see what mistakes they had. I can't tell you the percentage, but if you look carefully at car foreclosure cases, frequently the creditor makes a mistake and doesn't have a right to claim the deficiency. So if you've got someone in your office that's familiar with it, look to see whether they followed the UCC. Did they do all that was necessary to be able to get a judgment? Did they conduct the sale in the correct way? Now, I say that that happens in a significant number of cases where you actually have the deficiency, but I find it really troubling to deal with these car loan deficiencies because the majority of them, they can get the deficiencies. People signed a contract that's valid under the applicable state law in where you're at, and it allowed the bank to repossess the collateral, and it did it and to go after deficiency. And if that's the case, they're going to get sued. And if they have money, they're going to, if they're making enough money, their wages could be garnished. If they're not making a lot of money, then maybe the judgment-proof defenses are still available that we've talked about. And was there another question?
Yeah. Somebody else asked, what can be done to protect credit ratings during debt collection?
One of my slides, I'll talk about debt, credit ratings, but the short piece is, if you're not paying your debts, you're going to have hits on your credit. If you can work out deals and get your creditors to report it as paid, your credit can improve a little bit. But a lot of the people in the lowest levels, if they qualify for our services, we'll talk about this in a little bit, that the importance of a credit report or a credit rating is really overrated. And it's it shouldn't be the highest priority, but we'll talk about that in more detail a little bit later in the presentation. Any other questions, or should I move to number 8?
There's one that's just more of a comment, so I'll just read it and
okay.
see if you want to comment on the comment.
Okay.
It says, in New York City and perhaps some other places, it is important to know which programs are available and which are not. For example, a low-income person who falls behind in rent and meets legal services requirements can get legal services help fairly easily, and legal services can keep the case going for quite a while to give them time to either get more money or move. Also, everyone is entitled to emergency housing, so you won't be on the street, although it may be miserable living in a shelter. The shelter will try to get you into housing. Also, certain charities are helpful for certain things, and other charities are helpful for other things. So you need to have that knowledge.
Right. I think that's a very good comment. And what we find in Washington State is that there are more resources available in Seattle. The people that seem to get hit hardest sometimes are in rural areas where there just is, you need a car. So if you lose your car, there's no bus service. There are no shelters nearby, and sometimes you have to look at faith-based resources and others. But knowing what's available is really critical in dealing with these situations. Shifting to slide on dealing, the 8th rule is that loans with only household goods as collateral are also of low priority. Shift to my caveat on this is that a lot of times creditors just really don't want the property. You have to be careful of the rent-to-own people, because in various states, rent-to-own people, we've seen that what they do is we've seen this outrageous behavior is that rent-to-own people will say, when you don't give it back, it's not that it wasn't a secure transaction, but somebody has stolen their collateral, and they do some outrageous things. So rent-to-own can be troublesome. Other places we've seen across the country, it was a terrible situation. Sears was terrible in that, and some others have done it. Les Schwab, a tire company that sells tires in the Pacific Northwest and maybe in California, has done some interesting things too. But a creditor, it used to be you'd go into Sears and a person would buy an appliance, a washer and dryer or whatever, and if they bought it over time, they were always giving Sears a security interest in the collateral. And Sears could take the washer and dryer back. Is Sears going to show up and take the washer and dryer? Or I saw one case where the person granted a security interest in the lawnmower that they bought from Sears. They moved. As they were moving, they had the lawnmower strapped to their top of their car. The strapping came undone, and somewhere along I-5 was a bashed up lawnmower. But Sears nonetheless came in and said, hey, you've deprived us of our collateral, you're going to have to pay us. Les Schwab has done something of interest, is that people will go in and they will buy their tires on credit. And then Les Schwab will be pushing them, saying, you know, you've got 4 used tires that are half done but they haven't been paid for. Is Les Schwab really going to go out and take away the tires, repossess the tires? No, but they make a lot of threats that they will. And they make a lot of saying, you really need to have good credit with us at Les Schwab or you're not going to be able to buy your next tires. Well, a lot of those things have been time-tested by the creditors to be able to fleece the people from their money. But a lot of times, maybe if your couch looks like this one that I'm showing on here on the slide, it may be just better just to let them take the couch or call their bluff because they may not take it. The number 9 rule in the book was a debt should not be moved up in priority because the creditors threaten suits. People get scared. People don't understand what a lawsuit is all about. And you know, they don't know whether they're going to go to jail or whatever. My caveat to this is that even if the threat is real, it takes time to get a judgment. You know, the Washington timeline, which is similar to most states, is first the lawsuit, people can threaten a lawsuit, but if they don't have a judgment yet and your client needs 30 days to get things squared away or whatever, they can do it. The threat of a lawsuit doesn't change that. The timeline in Washington is the lawsuit has to be served on them. They have to give them the summons and complaint. We often see clients that will say, well, they gave it to my brother, or they left it at the place, but I never handled it, but they know about it. Judges don't buy that. You know, the fact that the dog ate my homework excuse just doesn't work. If the people know of the lawsuit, you know, they really should respond. In Washington, you have 20 days to appear or answer, so you can't get a default judgment from the date of the, you know, on the date of the service. There's 20 days to go by. Even just a notice of appearance, a short notice of appearance saying, I'm involved in this case, I intend to answer, will prevent most creditors from getting a judgment, or a short answer. Now, the client may not know for sure, you know, if the debt was bought by somebody else. They may not recognize it, or they may dispute it all. You don't have to say, this has never been my credit card, I don't owe them anything. If that's not true, you don't want to say that, but it can be true. It can prevent somebody from getting a judgment right away to answer it and say, you know, I'm not sure that I owe that much money. They're going to have to prove to me that they owe that much money. You know, once you get an answer in, so therefore I contest it. An answer forces the creditor to either go to trial or try to prevail on a summary judgment motion. But a short answer buys between a month and a year in Washington and most other states. So again, the threat of a lawsuit is not the big deal. You can't garnish until the judgment is obtained. And even if a judgment is obtained and people get their lives in order and start making money in the future so that they're no longer judgment proof, just because there is a judgment obtained, a judgment like a regular credit card debt, it doesn't change its nature. A judgment is dischargeable in bankruptcy. A judgment claim is dischargeable just as if it was still just a credit card claim.
Fred, I just want to let you, I'm taking a look at the clock right now. We've got about 26 minutes left.
Okay.
So I just wanted to give you that heads up.
So that's good. The big fear that you always have in giving one of these presentations is running out of time. What I would hate to do is come up at, come up 20 minutes early and say I have nothing more to say.
Right.
Well, so I think, thanks though for the warning, and give me another one as I go through this too.
Sure thing.
Rule number 10, do not pay when there are good legal defenses to repayment. In the debt collection world, what we see very often is that there's a statute of limitations defense. Debt buyers have bought debt. And they bring, in Washington, our statute of limitations is 6 years. A lot of times they'll be bringing debt, claims 6 to 7 years after the debt was there. Often we see FDCPA, the Federal Fair Debt Collection Practices Act violations. Other things we see, the world has changed. A lot of collections are now done by debt buyers. The industry used to be, you'd assign, Macy's would assign its accounts to a collection agency, and the collection agency would keep a third of whatever they collect. Now Macy's doesn't do that. Bank of America doesn't do that. They sell their debts in pools to companies like Midland Funding and Portfolio Recovery Associates. What that does is that sometimes these debt buyers, they don't have the proof to be able to prove their claim. Your client can answer a lawsuit and say, I don't think I owe the money. You better prove it. And they may not be able to prove it. And we've also found in Washington that Portfolio Recovery Associates, which filed thousands of collection actions in Washington alone, was not licensed. Nobody ever raised that issue. And when we raised it, we got two big law firms, multi-state firms fighting us on that issue. But the law was clear when you read the statute that debt buyers, if they solicit claims for collection, are under our collection agency law and they have to be licensed. Another defense we see is that sometimes the debt is just not owed. We see people with similar names, or they sue a spouse, but they don't have the fact that they don't, the other spouse has the car, but they don't have proof that our client was living with the person at the time or ever signed on the debt. They just may not have the ability to prove it. My caveat on this, I love this picture. Here's my low-hanging fruit picture, is don't let creditors take a default. Creditors go after the low-hanging fruit. My review of cases here is that, Midland Funding, for example, which is a big debt buyer, they will serve, you can serve process in Washington before you file. What they do is they serve people with the summons and complaint, and those that don't answer, they take a default judgment. And you think that if somebody doesn't answer, maybe they can't collect it, but our research shows that in the vast majority of cases that they get the default judgment, they still are able to eventually issue writs of garnishment or attachment, and so they still collect. In those cases where we have answered before they filed, they never file. We break the cycle, with an answer, and sometimes they look for an easier person to get. If the lawyer shows up, I sometimes call this my suit defense. I show up wearing a suit and they give up. Again, we talked about judgments move up in priority, but not as much as people would think, because a lot of times people are, are judgment proof. My caveat, in every state there are exemptions that provide some protection of debtors' earnings and assets. And many survivors of domestic violence are judgment proof. 15 U.S.C. section 1673 is the law that applies across the country. This is federal law. 30 times the federal minimum wage per week is exempt. So minimum wage is now $7.25 an hour. So if somebody's take-home pay is $217.50 a week or less, they can't lose a nickel. Now, make sure that your client is having their taxes withheld because it's disposable earnings. It's not gross earnings. This $217.50 is disposable earnings. And many states have more generous laws than the federal. Some states have provisions that provide for exceptions for undue hardship. Some states let the exemption go up higher when there's dependents. Some states, like Washington, have raised the exemption limit to, ours is 35 times the state or the federal minimum wage. Some states base the limit on 40 times the federal minimum wage. Some use it based on 30 times the state minimum wage, which may be higher. But there are exemptions. The 12th rule was student loans are medium priority. Student loans are getting to be a big problem. There is now more student loan debt than credit card debt in America. It's amazing how big this is received. In some instances, people are fooled into buying a bad product. Educational Credit Management Corporation and others that collect it, they're tough. They're tough to work with. There are special laws and there's some special laws. Like Washington has a law that says, and collection agencies will use this, if you don't make good faith efforts to pay your student loans, you can lose your professional license. That's true for every profession in Washington: doctors, beauticians, tattoo artists, anybody that has to be licensed. They don't pay their student loans, they're at risk of losing their professional license. The only exception to that rule in Washington is for lawyers, because lawyers are governed in this state by the Supreme Court and not the legislature. There are special tools for that student loan creditors can use, but there are also hardship programs. The 13th rule, debt collection efforts should never move up a debt's priority. This is very similar to what I've talked about before, which was in Rule 9. Again, threats should not be what our clients work on, because a lot of those threats are not honest. My caveat: collection agents have been known to lie. We get collectors calling people across the country saying this is Sergeant Smith, that somehow, and they talk about, people can go to jail if they don't pay their debts, that they're going to call their parents, or they're going to call their pastor, or they're going to do something else. A lot of these things you can't do. What you have to remember is the collectors are on a commission. They're doing whatever they can do a lot of times to collect money, because if they don't collect money, they don't get paid. I'm on the Washington State Collection Agency Review Board, which reviews collection agency practices, and it's half citizen members, half industry representatives. And the chief of one of the large collection agencies in Washington, the chief executive officer, admitted to me that when he started doing background checks on his employees, that he was very surprised by the results and immediately had to fire some people. I'm not sure. I had even some clients that have been collection agents, and there's some that are honest and they're doing their job right, but there are some people that are drawn to the business that you've got to question. Their affairs. Any other questions that we have, Erica, that we should, or Sarah?
One person says, what if a creditor gets a judgment against someone and claim they served the person by tacking it on the house when the person didn't live in that house any longer? The person did not know they had a judgment until they tried to get a loan, and the company who got the judgment went bankrupt and isn't even in business any longer, but the judgment is still on the person's credit history.
Well, if somebody else has acquired that judgment, a couple parts of that question. In the Federal Rules of Civil Procedure has 60B. Washington's Rules of Civil Procedure has 60B. That's very similar, and most states have something like that. You can, and we have to do this a lot, in that you can vacate a judgment that is void at any time. If service was not accomplished, and you can show that the service was never made on your client, you can vacate that judgment. If you can show that service was made or arguably made on your client, but there was excusable neglect, that the client was in the throes of mental issues at the time and didn't know about it, or it was served on somebody else and not given to them, somehow there was excusable neglect, or they didn't think it was theirs. If you have excusable neglect and a defense, you can vacate the judgment within a year of its being entered. If you were neglectful, even if you have a good defense, but were served and more than a year has gone by, you get down to the position that your only defense may be bankruptcy. This is where we talked about on the Rule 4, threats to ruin one's credit record should never move up a debt's priority. This smiling character, I don't know if you remember the commercials. I think he was the singer that was talking about credit. But credit is important when you're in a stable relationship, have a good job, and have saved up a down payment and are about to buy a house. But for many others, the value of good credit is really overrated. I often think that it's like the commercial industry out there telling us that we stink in a place that we didn't know we had. You have to be careful. My caveat is, I used to use a slide for this because Nordstrom started in Washington, but Nordstrom's is not all over the country. Macy's is. Credit is important if it makes a difference between getting a home loan at 6% or 4%. But if you're buying a shirt to wear to work and you're buying at Macy's, Macy's will still take cash for a shirt or a sweater. So, credit is important, but a lot of people spend too much time worrying about their credit report when they should be worrying about other things. Co-signed debts. If both parties signed for a loan on a Ford F-150 pickup, and even if, and if that Ford F-150 pickup is not in your client's hands, it's being driven by an abuser and is in some other state, and that the abuser was awarded that liability in the divorce or in some court proceeding, the banks don't care. The banks, if one person, it doesn't matter who really ended up with the pickup, if both people signed on the loan, if they can find your client, they can still go after your client. Okay, we'll go for another question here.
Okay.
Okay, the options are, should my client take out a second loan on her home at a 10% interest rate in order to pay off credit card debts accruing interest at 24%? B, should she use her IRA to pay off the high interest loans? Should she do both, or should she do neither?
Okay, I'm going to close up the poll.
Okay. And the winner is? The biggest responder was no answer, but the second one was neither A nor B, and that's right. You don't want to impair your home equity. Usually, taking out that second home loan, there are some cases where consolidating, if you can get a lower interest rate, great. I mean, if someone really has access to a line of credit and that's a 10%, it's better to have a 10% line of credit, unsecured line of credit, than a 24% credit card balance. So looking at your various accounts can make sense, but usually when people are refinancing, what they're doing is often the banks are looking at and it used to be household finance and others that would do this, looking at what equity people have in various assets. And if there's equity in a home, which might otherwise be exempt from execution, the exemption doesn't apply if a debtor voluntarily gives it away to a creditor. Similarly, with an IRA, you don't want to use your IRA, which is an exempt asset, to pay for credit card debts. A lot of times we'll see people wanting to keep their home at all costs, but they're not going to be able to keep it. They just don't have the income to cover that mortgage anymore. And what they'll do is they'll end up making partial payments, but they'll rob their IRA or their pension funds to be able to pay it. The problem with that is that once you've lost your pension assets or pledged them to another creditor, you've lost that exempt nature. If you're going to lose the house anyway, don't lose your pension assets as well. This is the bonus rule number 1, which we've talked about a little bit again. Creditors with access to accounts should be forced to lose their priority. Close any bank accounts in which a payday lender has access. There's a double whammy. Let me go back to this real quick. There's a double whammy that can happen. If you have 25%, or your client has 25% of their wages being garnished, and there are also deductions, voluntary deductions coming out of their bank account, what happens is less goes in the bank account, and then once it's in the bank account, it can be nabbed. And creditors really can, well, creditors can be in a position with that to basically get much more than 25% of the wages, and in some instances deprive one of our clients of all their assets. Again, this is the bonus rule 2 is dealing with the IRA accounts. Only use the IRA if you need to. I mean, if it's an issue of making sure that you're fed, well, you can worry about your retirement later. But if it's an issue about dealing with credit card debt, debtors can't get to your IRAs or your pension assets. They're exempt. We're getting close to the end. I'll leave a few moments at the end for questions as well. But bankruptcy is a tool that's always out there. I like to refer to it as a silver bullet. Maybe most of you are probably not as old as me and remember the old Western with the silver bullet being so special, but you only have one of them. You want to use the bankruptcy tool when your client has hit the bottom. If there is going to be some large medical expenses coming up, your client is about to get employed again and is going to have medical coverage in the future, but doesn't have it now, but does have a sick child, and is going to have some bills that they're just not going to be able to pay, you don't want to file bankruptcy too early. You want to file, I like to think of things, visually, and if I think about this like in a sine curve, you want to you do the bankruptcy when you've hit the bottom and about to come up again, so that you can cover things in there. Another rule that I think is true across the country is good bankruptcy lawyers don't charge more than bad bankruptcy lawyers. And if your office or you don't know who is good at doing bankruptcy and what they charge, ask around. For the benefit of anybody that's in Seattle on this one, for example, there's Ruth Nelson in Ballard, in a suburb of Seattle. She'll charge people $800 to do a personal bankruptcy. And if we have clients that really need a little bit less than that, she sometimes will take a little less. But $800 plus the $306 filing fee means someone can go into bankruptcy for $1,100 bucks. Now, that's a lot of money, but again, you don't put somebody into bankruptcy until they're in a position to have something to lose, that they actually have wages that could be garnished. And if wages start getting garnished, 25% of the wages are going to get garnished, that's enough that usually in a very short period of time would cover that $1,000 bankruptcy. So we don't do a lot of bankruptcies here at the Legal Services Corporation because our clients usually are judgment proof. They don't need it. But as they start getting on their feet, again, even if judgments were entered against them, judgments are no different than just regular credit card debt. they're, you know, when the things are starting to get better, the bankruptcy may be a very good idea to get them to zero. You know, get them to so that the bottom, they get rid of their medical debt, they get rid of their credit card debt, and when they start making their wages, they can save that stuff, use that for their expenses, and not have it garnished. One thing we found, and I'm really careful about, is that pro se bankruptcies are not usually a good option. We just, you know, making sure, you know, if you have, you know, we've had one case where our client was a legal assistant in a tort law firm. She understood forms. She understood that. We were able to help her and talk to her about what she could do. But a lot of our clients are just not an ability to be able to figure out all the forms and get everything done. The person that was from New York that mentioned this, there are some pro bono bankruptcy services out there. If they have them in your area, great. If not, find that reasonably priced bankruptcy attorney. So if I'm looking at my clock right, we're about 5 minutes before the end. Is that right, Sarah?
Yes, we are 5 minutes before the end. So,
okay,
I've got a couple of questions that we can entertain, if that works for you.
Yeah, I think that's good. I was shooting to have a few minutes here at the end to entertain questions. So. Okay.
One person asks, can you give suggestions on how to advise a client who's receiving wages below the minimum garnishment level on how she can protect those wages once they come into her possession, particularly in jurisdictions where there are no protections for a minimal amount held in a bank account?
Yeah, that's a tough one. We've been trying to push here in Washington, saying that you know, you've got to leave more than $500 in the bank account. If the rent is going to be $1,000, you got to let their rent. You got to let people that are getting paid on a weekly basis put their money in the bank account to be able to then go ahead and, you know, put it in a bank account so that and save for their rent so they can do it. Otherwise, you create people. You put them in a position where they have to put their money in their mattresses. And if you're in a state that has no protection for savings, and you know you're making $200 a week, but you've got to pay $600, so you've got $800 that you're coming in, but you're going to have to pay $500 in rent. You can't pay the rent with one check, so you have to accumulate it to be able to get to the rent. You almost just have to take it in cash, so you can't put it in a bank account, or if you don't want to keep it in a bank account, see if you can work with your landlord so that once you get your money, that you quickly use it right away, use it up. I mean, sometimes you got to get an employer that will do a hard check instead of you know, direct deposit, and you need to work with maybe your landlord, and instead of you get that paycheck, endorsing the paycheck over to the landlord and paying the rent in installments and paying it, you know, earlier than necessary. Taking your check and going down and buying food with it right away, as opposed to you know, putting it in a bank account and then writing a check. It's tough if there's no ability to exempt money in a bank account. I'm not sure which state that question came from, but that's a tough one. Okay. Another question?
I think that's all of the questions for now. The other ones were sort of just comments along the way. So I'm looking at the clock, and I think it's time for us to wrap up, unless there are any final comments that you want to make, Fred.
No, I hope that I was helpful in this. I think I'm much better.
Helpful.
Well, it's much easier to do this when you can see people's faces and you can talk about the stories. My email is fredc@nwjustice.org. That's the best way to get a hold of me. If if anybody in the audience thinks that I could be helpful in an issue that they have, I'm quite willing to entertain email questions.
Wonderful. Well, Fred, thank you so much for your really thorough and incredibly thoughtful presentation today.
Well, you're too kind.
I learned a lot, and I'm sure others have as well. The Center for Survivor Agency and Justice is absolutely dedicated to focusing on this issue around debt for survivors, and we welcome questions from everyone out there and your colleagues as well. So if you are struggling with case-related issues, please feel free to get in touch with us. You can actually access us through the website. There's a way of submitting a request, or you can just shoot us an email. And we'll get you the expertise that you need, either by putting you in touch with Fred or helping you think through it in other ways with folks in your community. So please feel free to reach out to us. We're also interested in hearing about really great work that you are doing around this issue and other consumer law issues. So please keep us posted about the work you're doing. In addition to thanking Fred, I want to thank all of you for joining us today and being active participants. And of course, we want to thank the Office on Violence Against Women for funding today's program and our project as well. My last pitch is to please take a look at the evaluation link that will pop up at the end of today's program. We really listen to your feedback and want to hear what your thoughts are so that we can use that information for future programming. So please do fill out the evaluation at the close of our program today. Thank you all for joining us, and have a great afternoon.